We're now going to discuss this further. We're joined for analysis via Zoom by legal expert William Booth. Always a pleasure to see you. Thanks very much for joining us.
Pleasure to be on the show. Thank you.
Well, let's start with what the Judge Koen had to say. Not usual that we hear about an appeal process then being allowed to take its course. Sine die that he mentioned. A lot of people who might not understand what that legal term means would want to understand and want it to be unpacked further, but certainly meaning that not a specific date being placed as to when the trial will resume. I mean, that will resume. Not a usual thing to happen, but certainly we're faced with something that's quite unusual. What are your thoughts? And perhaps if you can unpack this for us legally.
Well, as the judge said, criminal matters are never postponed sine die. Yeah. It normally relates to a civil case. So what it does mean is, in Latin, that it's postponed not to any specific date, and that at some point the various parties will then arrange a date. But what Judge Koen has done is obviously to set dates. He has set certain dates, so that would be in order for that to obviously happen. Because we don't know yet what the ruling is going to be, obviously, from the President of the Supreme Court of Appeal, number one, and we don't know how long that's going to take. So one would hope that it obviously is done very quickly, but that depends on the court role at the Supreme Court of the Appeal, and the registrar would obviously allocate, certain dates and make sure everything is filed for the President of the Supreme Court of Appeal to deal with it. Yeah. So in terms of the Superior Courts Act, you can petition the Supreme Court of Appeal, which Zuma has done. Two judges heard the petition and felt there was no reasonable prospect of that petition succeeding in respect of obviously overruling Judge Koen's decision to have Mr. Downer removed as lead prosecutor in the state's team. So the Superior Courts Act makes provision, as is indicated by Judge Koen, to take the matter further to the Supreme Court of Appeal. That is to approach the head judge there, being the president. So it's a procedure, but that will only succeed in very, very exceptional circumstances. So my view, it's highly unlikely that the president of the Supreme Court of Appeal is going to overrule what the other two judges have said. But having stated that, I don't know exactly what has been set out in the papers and maybe added to by Zuma's legal team. So, but all I can say, it is very unusual that the president of that court does then make a decision different to what two other judges have made. Yeah. So the provision is there, but I don't think it's going to be, my view is anyway, I don't think it's going to be successful.
Yeah, the parties have indicated that the process might take about 2 to 3 weeks. That's as we await, of course, President Maya's judgment on the matter. Is that likely to happen? I mean, we've seen this matter being drawn out, and of course now we're dealing with a side issue, a side matter, which might also then take some time there.
Yes, look, it's very difficult, and that's why these sort of holding dates, as Judge Koen refers to them, were fixed, because, we don't know how long it's going to take. But my hope is that it is done as quickly as possible, because it's holding up a case that has taken years and years to be set down for trial. It was set down a few times. We've had dates now that were set down. Obviously, it's prejudicial to the state and prejudicial to the other accused in this matter, because I'm sure they want the case to be dealt with. The longer it takes, I don't think that can be in the public interest. I don't think that's in the interest of justice generally, if a case takes this kind of period of time before it even starts. So, but having said that, let's say this is dealt with in 3 weeks' time. Then the next step that Zuma's legal team could consider is petitioning the Constitutional Court. And I think mention was made of that during the proceedings. So that could be a further delay. So then they would have to come back to court and ask Judge Koen, please give us an opportunity to continue with a petition to the Constitutional Court. So they filed their petition to Judge Maya, and already. So I think that's why Judge Koen has granted the postponement.
Yeah.
And I think he would rather look to be fair in all regards, even though I think my view is that he could actually have refused the postponement and said that there's an unreasonable delay and that is seriously prejudicial to all the other parties, and have refused the postponement. But his view was, well, he seems to be bound by the fact that he had to give the postponement. But he's given the postponement.
So ultimately, giving that what the judge terms and what you've referred to as the holding date, could that be seen as Judge Koen's way of digging his heels in? Because obviously the defense would have wanted them to have a situation where there's no date, sine die, as you refer to it. I know you're saying it differently to how the judge called it, by the way. But in any case, would they have, obviously it would have worked in the favor of the accused had there not be a specific date being put. So I'm wondering if this particular holding date that's been put there was really a sign of Judge Koen saying, listen, I'm digging my heels in, I'm giving a date, even though ultimately that date might not actually get to start on that particular date.
Yes, I think he had to set dates, and I think he did so correctly. So, I'm sure in his own mind, if I may say, he probably was very reluctant to grant the postponement because, the case has to start. So by fixing these holding dates, he is, I think, as you say, correctly so, trying to set, going into the future, time limits. Although he can't hold the President of the Supreme Court of Appeal to those time limits, because they might say, well, we need more time, or we might need more argument, or it actually might be dealt with even before those dates. So he said that if it's done before then, well, then here we have dates set for trial. But what I said a few moments ago is, if she says no, there is no reasonable prospect, there are no exceptional circumstances or motivating factors, whatever words you want to use to describe the situation, which is unusual. This, as I said, a procedure that's quite unusual, and only in those very exceptional situations will the petition succeed, this kind of petition. They could come back and say, well, we want another date because we're now going to the Constitutional Court. So then it will be interesting to see exactly what Judge Koen does in that, if that should happen. So that, looking at the history of this case, again, every kind of move is made to kind of prevent it starting. I think everybody knows that. And the state are obviously extremely furious. They've got witnesses and they want to get on with this case, and they've been blocked at every turn. So, and I don't think there's much, if any, merit in this petition to have Downer removed as the lead prosecutor. And my view on this is, well, even if he is removed as the lead prosecutor, that's not going to stop the case. There are lots of senior prosecutors out there, people who've worked on this case, who could step into Mr. Downer's shoes and quite effectively and efficiently take over the matter. So, it's not about let's get the case completed if we get Downer off the case. That is never, ever going to happen. So is there any, just really, why is this being done? It seems to be, in my view, other than causing delays, it doesn't seem to be sensible to deal with the case in this way.
All right, Mr. William Booth, thanks very much for giving us your time here on SABC News. Much appreciated. Legal expert William Booth speaking to us. Of course, we're talking about what's going to be the private prosecution now of Advocate Billy Downer.